Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with Donald Trump, who has filed a lawsuit relating to the search of his home at Mar-a-Lago. This, of course, is part of a continuing series. We have realized that, the president's home has been searched. We have discussed it and looked at it and all the things, and yeah, it's definitely a thing that's happening. And now Donald Trump has filed a lawsuit, and we're going to review this to see what it has to say because that will be fun and entertaining. So let's go ahead and do that. We're going to review this. Okay, just getting everything ready so everything looks all spiffy and fun in the morning. Great. Hello, everyone, by the way. Let's go ahead and get started with the coverage. Great. Okay. So this has been filed by Donald Trump in the matter of the search at Mar-a-Lago at 1100 South Ocean Boulevard in Palm Beach, Florida. Okay, so what does Donald Trump want? Let's go ahead and read this. Let's discuss the law. Let's go ahead and get started with this. President Donald Trump, by and through his assigned counsel, respectfully files this motion for judicial oversight and additional relief, which seeks an order that appoints a special master, enjoins further review of seized material by the government until a special master is appointed, requires the United States government to provide a more detailed receipt for property, and to require the government to return any item seized that is not within the scope of the warrant, and states as follows. Okay, so we want a whole bunch of things. Basically, we want more careful review of these documents. Now, what is a special master? So a special master is a term of art. It is a person appointed by a judge to oversee a portion of a case and basically acts as a mini judge. They act to review something independently. And it's usually it's always an attorney, and sometimes it's a former judge or something like that. But it's someone who's appointed to oversee a case. Now, depending on the scope of the thing, right, a special master can have lots of different roles. They're often used by the United States Supreme Court as basically trial courts to review things. So they can have almost the same amount of power a trial court has in terms of reviewing things. They can be appointed just to do discovery. They can be appointed just to do things, one thing or another thing, right? But they're basically an appointed judge to review something, somebody who's independent of the parties. And the judge themselves, of course, can perform this role. But one of the reasons that you have a special master is to isolate the judge. And one of the reasons you might want to do that is to avoid the judge themselves from being biased if they have to review documents down the road, right? That way the special master makes the determination and it can help to isolate the judge. So that's what a special master is. It is a tool that exists. It is not common, but it is more often used in more complex cases, especially complex technical cases, where you need someone with particular technical expertise. So it's not something you see very often, but it's not unheard of, and it's not a superficially unreasonable request. The part where we want to deny the Department of Justice the ability to review the documents, though, that's going to be trickier. We're not going to be able to get that, I'm pretty sure. But to have someone else review them, yeah. And he would be entitled to return the stuff that was seized that's not within the scope of the warrant in any event after it was inventoried, but he's filing for it anyway. Okay. Politics cannot be allowed to impact the administration of justice. It's a little late for that, but I appreciate your thoughts on the subject, to be sure. But I think politics is somewhat inevitable in this kind of matter. President Donald Trump is the clear frontrunner of the 2024 Republican primary. Yes, I think that's true. And the 2024 general election, should he decide to run. I think that's probably true too. Beyond that, his endorsement in the 2022 midterms have been decisive for Republican candidates. They've been influential, that's for sure. On August the 8th of 2022, in a shockingly aggressive move, and with no understanding of the distress that would cause most Americans, roughly 24 special agents of the Federal Bureau of Investigation, directed by attorneys of the U.S. Department of Justice, raided the home of the President Donald Trump. Yeah, searched, raided, depends on your same exact thing, just has a different connotation, right? Same denotation, different connotation. Raided and searched has the same denotation, most different connotations. By the way, just as a FYI, in case you're wondering what a special agent is, a special agent is just someone who has the power of arrest, right? Everyone who works for the government is an agent, right? We've talked about agency principles. Like anyone who works for any kind of business is an agent, right? We talk about agents and principles all the time, right? If you work for a business, you're an agent of that business. You're an agent of the person. You are their stalwart. So anyone who works for the government, it can be properly deemed an agent. What makes someone a special agent is that they have the power of arrest. And so everyone who conducts searches has the power of arrest, right? Not necessarily everyone who works for the FBI, by the way, has the power of arrest. They do have people who don't do powers of arrest because they have all kinds of people beyond, all kinds of support staff, for example. But that's what makes a special agent is they have the power of arrest. Just FYI. Okay. According to the government, the agency's documents, privileged and or potentially privileged materials, and other items, including photos, handwritten notes, and even President Trump's passports, that were outside the lawful reach of the overly overbroad warrant. So he's still saying the FBI has the passports. They say they don't. But we'll see. Who has the passports, I think, is a reasonable question. President Trump, like all citizens, is protected by the Fourth Amendment of the United States. Correct. Property seized in violation of constitutional rights must be returned. That seems fair enough. Law enforcement is a shield that protects Americans. It cannot be used as a weapon for political purposes. Therefore, we seek judicial assistance in the aftermath of an unprecedented and unnecessary raid on the home in mar-a-lago. From the first moment, the government informed movement, that'd be Donald Trump, through counsel that a search was underway. He demanded transparency. Movement asked the government the questions that any American would ask under circumstances, namely, why raid my home with a platoon of federal agents when I voluntarily cooperated with your every request? I think the U.S. government would deny that premise. What are you trying to hide from the public, given that you requested I turn off all home security cameras and even refused to allow my attorneys to observe what your agents were doing? How did they make that request? And you don't have to agree. You could just say no, which I understand there might have been tape made. Like, yeah, we want you to turn off the tape. How about no, it's my house, screw you. Whatever you refused to tell me that you took from my home. Okay. As set forth in detail below, the government has declined to provide even the most basic information about what was taken or why. However, the scant information the government has provided, a vaguely worded receipt for property, and the warrant itself, raises significant Fourth Amendment questions about the unprecedented and unnecessary raid. There are significant Fourth Amendment questions, to be sure, that, they are present in most searches, and this one is certainly different. This is not just your average ordinary search. This is, no matter how you slice it, this is a different beast. For instance, the government has informed counsel for President Trump that privileged and or potentially privileged documents were among items taken for home. How would the government know that? But okay, and that's one of the things they're supposed to do, is look for that information so that they don't read it, right? And they have their own internal processes for reviewing that to try to prevent that. They have their own sort of internal processes to review information for privilege before it gets to the Department of Justice so that they can look for that kind of stuff. But the government has refused to provide any information regarding the nature of these documents. The Supreme Court has held that documents reflecting communications between the president and top advisors are presumptively privileged. That is true. So they might be privileged because of executive privilege. But then again, the question might be whose privilege is it, right? It's not necessarily a personal privilege. It would be a privilege held by potentially the president, and he's not the president anymore. So whether or not he can invoke that privilege is not at all clear. While he was president, yes, but he's not president anymore. So if it's like documents between him and his attorney, that's a personal privilege, right? This is the difference between talking in your official capacity versus talking in your personal capacity, which is the broader legal principle here, right? If it's me, personally, if I'm talking to my attorney, that's a personal privilege. But what if it's me and I'm like the CEO of a company, right, talking to corporate counsel, right? Then it's not me that's talking to corporate counsel. It's the corporation talking to corporate counsel, because the corporation is the clients, right? Not me personally, even though I'm the CEO. If I stop being the CEO, right, the new CEO is the corporate designee in this example, right? So the privilege belongs to the corporation, not to me. So if I talk personally to my own private attorney, that information is protected and only I can waive it. If the corporation is talking to a attorney, that privilege belongs to the corporation and only the corporation can waive it. It doesn't belong to any individual person. So the same sort of logic would apply to the president. So if Donald Trump is talking to his own personal attorneys in his own personal capacity, personal privilege. If he's talking to his own staff or the White House counsel or something, he's talking in his official capacity, then it's not his privilege, strictly speaking. It's the privilege of the office. And he is no longer in control of the office. So it might have been privileged. It might not be privileged. Well, it might be privileged. It's just not his privilege at this point. It would be Biden's privilege. So there's a bit of a flaw there on that analysis. Yeah. And by the way, and someone asked about the whole passports thing. Yeah, it wouldn't be uncommon for a person to have multiple passports, particularly a governmental official. By the way, same reason why, right? Personal versus official passports, right? So if you yourself individually apply for a passport, right? You get a personal passport, which in the United States at least has a blue cover, right? So if you have a blue cover, it's a personal passport. However, of course, if you're traveling officially on official business, right, then the government is going to give you a passport for that reason. In which case, in the United States, it has a maroon cover. And then, of course, there's the special passports for the diplomatic passports, which, show that you have diplomatic immunity. And those passports are black. So yes, the United States passport comes in a variety of colors, depending on it. And of course, someone like President Trump would presumably have all three. He'd presumably have a black diplomatic passport, a maroon official passport, and a blue personal passport. And he could have expired passports. So passports for everybody. Many, many passports. All right, going on. Yes, Lupin claps back. I thought it was a creative title. For instance, okay, we read that. Protection of the integrity of these documents is important, not only to the movement, but also to the institution of the presidency. Yeah, but they might be the presidency's documents. And you're not the president at this time, so it might not be your privilege at all. Pinky Less Pirate says, doesn't erase past presidential privileges declassification. I wouldn't view it as a past privilege, rather view it as past actions. Yes, stopping being president doesn't prevent the actions that you had from continuing to have effect, any more than they would in any business context. So in this context, the presidency is not really different than holding a job of any description, right? If you, in the course of your job, are performing some act that's within the scope of your job, then that action might have effects even after you leave. Because it didn't like the action was validly taken, right? So I mean, if you're anything, when you're doing your official job, those actions might have consequences that permeate. And if you stop becoming that office or whatever it is, then you can't do that anymore. But those actions are still valid. So yeah, him not being present or not doesn't impact his declassification of documents. Assuming he declassified documents while he was president, those documents would remain declassified until that classification status was changed, because his actions would have permeance. They would permeate, right, beyond it. Now, a future president might be in a position to change that, but his actions taken don't stop being valid the moment he stops being president. So yeah, him, if he declassified the documents before he left office and they weren't reclassified and he wasn't given notice or something, then that issue may be something that's available to Trump. But we weren't talking about classification. At this moment, we were talking about privilege. We were talking about certain documents being non-discoverable because they're privileged. And the privilege belongs to the office. So in that sense, it would stop the moment he becomes being president. Well, strictly speaking, it doesn't stop. It's just that he doesn't have the office anymore. The privilege continues to exist. It just wasn't his in the first place. So hopefully that clarifies some of that. Yeah. Okay. Significantly, the government has refused to provide President Trump with any reason for the unprecedented general search of his home. I disagree. It's a general search. General search here would have a technical meaning. I disagree with that. To date, the government has failed to legitimize his historic decision to raid the home of the president has been fully cooperative. Instead, faced with public backlash, the Attorney General has taken the unheard of step of announcing a press conference. He's willing to release portions of the sealed search warrant application. Yes, the same stuff that you already had yourself, Donald Trump, so that you could have released at any time. The government didn't really release anything in some sense because it was already sort of out in the open. Because it was already in a it was something you could have released at any time. Government leaks to federal media outlets have provided ever-changing and inaccurate justification for the politicized concept of the FBI search. There's some merit to that argument. These unsupported justifications by anonymous sources had a breakdown in communications between President Trump's representatives and the government, and that depicted the need to obtain a search warrant. Okay, I mean, that makes sense, to be sure. The actual chronology of events established there was no exigency for a forceful raid. They're not arguing exigency. If there was truly exigency, they wouldn't need a search warrant at all. You do understand how words work, right? Person who's writing this document. And there is no basis for keeping information about the raid from the public. They didn't. I mean, okay. Moral Movement therefore requests the court order the government to produce the information sought by the movement and other measures set forth. And there's been a whole issue with the title, by the way. And yes, it's common to refer to someone who held the office by their last title or their most senior title. So calling him President Trump is perfectly appropriate. He's not the president, obviously. He's the former president. And you can call him former President Trump. That's fine. But it's not like exactly unheard of to call former president just president. You hear it all the time. President Clinton, President Bush, President Carter, President, right? It's not uncommon. And the same thing for governors or senators or representatives. Like, it's not uncommon to refer to them by their last title when they leave office. So yeah, I mean, he's obviously not the president at the time, but it's well common to call him president. So that's not abnormal. All right, background. Let's look at some background. On January the 20th of 2021, President Trump and his family left the White House. Yes, they did. They were voted out of office. I like how he said left the office, left the White House. He doesn't say stopped becoming president or lost the election. I think it's a deliberate choice. I think he's trying to avoid saying like he lost the election, because he says, well, we left the White House. Fine. They moved back to their home at Mar-a-Lago in Palm Beach, Florida. Mar-a-Lago is a historic landmark, a mansion with 58 bedrooms and 33 bathrooms on 17 acres of land extending from the Atlantic Ocean to the Intercoastal Waterway, hence the name, which means sea to lake. I did not know that. I am informed. Consistent with every modern presidential transition, staff conducted the move on a condensed time frame. They are very, very fast. The movers at the White House are second to none. They can move in and out in no time. That move, like many moves undertaken by most Americans, involved boxes. It was done during the day with the boxes in full view. It's done at noon, exactly. And takes like 5 minutes. It's amazing. After President Trump and his family settled back into their home, employees at the National Archives inquired as to whether any documents were inadvertently transferred by movers to Mar-a-Lago. In January 2022, Movement voluntarily asked the National Archive movers to come to Mar-a-Lago to receive 15 boxes of documents, then brought by the movers to Mar-a-Lago so they could be transferred to the headquarters in Washington, D.C. On February the 8th of 2022, the National Archives made the following statement. Throughout the course of the last year, the Archives has obtained the cooperation of Trump representatives to locate presidential records that had not been transferred to the Archives. When a representative informed the Archives in December 2021 they locate some records, the Archives arranged for them to be transported to Washington. Archive officials did not visit or raid the property. Very exciting. Sometime thereafter, the employees involved in the White House and Department of Justice in the matter voluntarily returned 15 boxes. Trump was contacted because 15 boxes contained documents from his administration that were protected by executive privilege, and the council communicated with representatives of the White House, DOJ, and the National Archives regarding the matter. Okay. On May the 11th of 2022, Trump voluntarily accepted service of a grand jury subpoena addressed to the custodian of records for the office of Donald Trump. You voluntarily accepted a subpoena? Okay. Seeking documents bearing classification markings. Trump determined that a search for documents bearing classification markings should be conducted, even if the marked documents had been declassified, and his staff conducted a diligent search of the boxes that had been moved from the White House to Florida. On June the 2nd, President Trump, through counsel, invited the FBI to come to Mar-a-Lago to retrieve responsive documents. Okay. The next day, on June the 3rd, Jay Braff, Chief of Counterintelligence and Export Control of the DOJ's National Security Division, came to Mar-a-Lago accompanied by 3 FBI agents. President Trump greeted them in the dining room at Mar-a-Lago. There were 2 other attendees, the person designated as custodian of records for the office of Donald Trump and counsel for Trump. Before leaving the group, Trump's last words to Bratt and the FBI were, "Whatever you need, you just let us know." Responsive documents were provided to the FBI. Bratt asked to inspect a storage room. Counsel for Trump advised the group that Trump had authorized him to take the group to the room. The group then proceeded to the storage room, escorted by 2 Secret Service agents. Storage room contained boxes, many containing clothing and personal items of Trump and the First Lady. When their inspection was completed, the group left the area. Once back in the dining room, one of the FBI agents said, "Thank you. You did not need to show us the storage room, but we appreciate it. Now it all makes sense." Counsel for President Trump then closed the interaction and advised the government officials they should contact him with any further needs on the matter. So at least he's trying to make a showing that he's cooperating, right? The FBI might have a different story of this, just out of all fairness. but he's at least trying to say that he cooperated, right? Like the National Archives contacted us. We looked for documents. We sent them boxes. They sent us boxes back. We invited the FBI to retrieve documents. We showed them what they wanted to see. They thanked us. Everything seemed super smooth. We were cooperating. So whether or not that's true or not, but they're telling a story. So fine. On June the 8th of 2022, Bratt wrote to counsel for President Trump. His letter requested, in part, the storage room be secured. In response, Trump directed his staff to place a second lock on the storage room, and one was in fact added. In the days that followed, Trump continued to assist the government. For instance, members of his personal and household staff were made available for voluntary interviews by the FBI. Don't talk to the FBI. Don't just because the FBI wants to interview you, don't do it. In fact, just don't do it. It's like, we'd like to talk to you. I'd like to remain silent. Don't talk to the FBI. Just don't. They're made available for voluntary interviews. I'd be like, no, that's okay. I'm good. On June the 22nd, 2022, the government sent a subpoena to the custodian of records for the Trump Organization, seeking footage from surveillance cameras at Mar-a-Lago. At President Trump's direction, service of that subpoena was voluntarily accepted, and responsive video footage was provided. Okay. So we've provided the government everything they want, is the story. Despite voluntary assistance provided by Trump, the government took the unprecedented step of requesting a search warrant. The government sought an expansive and intrusive search of his office, all storage rooms, and all other rooms or areas of the premises used or available to be used by the president and staff in which boxes or documents could be stored. They're looking for the documents. They're able to look in any room or any other place where documents might be found. This is very typical of a search warrant, assuming the underlying premise, which I understand is a big assumption, but assuming that they're validly searching for classified documents, they can look any place the president has control over in which documents would be stored or could be stored. That's typical of a search warrant. So nothing exceptional here. The government also sought expansive definition of property that it could seize, which include not only responsive documents and associated boxes, but any other container boxes that are collectively stored or found together with the aforementioned documents. So that aspect is a little broad, but not necessarily inherently unreasonable. Like, we can take the documents and the boxes that they're in, and other boxes that are nearby because they also might have the documents we need. It's not absurdly unreasonable. So I don't know whether or not you're going to be able to attack that. I doubt it, but it's a reasonable thing to note, at least. Essentially, the government secured court authorization to seize boxes that just happen to be located near potentially responsive materials. I mean, yes, but yeah. The search warrant was signed. The government was given 14 days to execute, which is typical. Belying any actual urgency, the government waited 3 days. They had 14. To execute the search warrant. And also, who said it was urgent? It was important, not necessarily urgent. Early in the morning on October the 8th, 2022, a group of roughly 24 FBI agents gathered on the premises of mar-a-lago carrying boxes and other items. At approximately 9:10 a.m., Brandt telephoned counsel for Trump and informed him that a group of FBI agents was at Mar-a-Lago to execute a search warrant. Heated discussion ensued as to why the government did not make voluntary requests to further explore the premises, given the expansive assistance that had been provided. Okay, so yeah, they're saying at least we were cooperating, so what's the problem? Brandt then made several requests. The first request made by Brandt was that all closed-circuit television cameras be turned off. I'd say no. They're mine. Or I'd say yes, or I'd just lie. Be like, okay, yeah, sure. But not. Pursuant to mar-a-lago policy, in the absence of a court order, the request was declined. Good for you. Good for you. Bratt also requested the name of any attorneys who might arrive at mar-a-lago on behalf of Trump. In turn, counsel for Trump requested a copy of the search warrant, an affidavit. The affidavit he's not entitled to, but the search warrant he is. And asked to be provided with a list of anything seized once the search was completed. He's entitled to that. Bratt declined to provide the search warrant and affidavit, stating that after the FBI has finished their search, Trump would be provided with a copy. That's correct on timing. And a receipt, but not the affidavit. Yeah, that's right. Among other actions being taken after being notified of this unprecedented event, counsel for President Trump contacted 3 attorneys in the general area who agreed to go to mar-a-lago. Once they arrived, they requested the ability to enter the mansion in order to observe what the FBI was doing, which the government declined. It's like, yeah, we're not going to permit you to watch, and we also don't want you to watch, but yeah. Tape it, man. Tape it all. After approximately 9 hours, the FBI concluded its search. An FBI agent provided one of its attorneys, who'd been waiting outside for nearly 9 hours, with a copy of the search warrant. I wonder if the attorney billed for that time. I would. The FBI also provided a 3-page receipt for property. This provided almost no information that would allow a reader to understand what was seized. This is true. It's very, very generic. On August the 11th of 2022, counsel for Trump spoke with Bratt by telephone. The first item of discussion was a message from Trump to the Attorney General. The message was as follows. President Trump wants the Attorney General to know that he's been hearing from people all over the country about the raid. If there's one word to describe the mood, it's angry. The heat is building up. The pressure is building up. Whatever I can do to take the heat down, to bring the pressure down, just let us know. So he's trying to recharacterize this whole thing about bring the heat down, bring the pressure down, because this was leaked. That Trump said, I want to bring the heat down, like he's doing it personally for his own heat. And he's, no, what I meant was the heat of the country. So he's recharacterizing the conversation, which, I have no objection to. I'll just take note that's happening. Also, we don't know that isn't what Trump said, and that the media isn't just the one massively recharacterizing it, which the media lies all the time. So maybe that's exactly what Trump said, and it's like, well, Trump said he wanted to take the heat down of the political divisiveness, not the heat on him. So maybe that's exactly what Trump said, and maybe the media knew it, and maybe the media lied. These bold propositions are brought to you by Uncivil Law. In addition, counsel for President Trump asked Bratt to provide a copy of the affidavit to the agreement of a special master protect the integrity of potentially privileged documents, provide a detailed list of exactly what was taken from the home and where it had been located, and to allow counsel for Trump the ability to inspect what had been seized. Bratt declined all these requests. To end the call, counsel for Trump requested that all on the call keep the lines of communication open. Doesn't sound like it's going that well. Okay, just hours after this telephone call, the Attorney General took an unusual step of holding a press conference to deliver remarks regarding the search of the mar-a-lago and the government's motion to unseal the search warrant. Mr. Garland made no mention of President Trump's clear and unequivocal messages to him. In fact, the government made no response at all to President Trump's invitation to help reduce public consternation with the government after the raid. They sure did not. In pertinent part, they said, just now, the Justice Department's filed a motion in the Southern District of Florida to unseal a search warrant and property receipt relating to a court-appointed search. The search was on the premises located in Florida belonging to the former president. The department did not make any public statements on the day of the search. The former president publicly confirmed the search that evening, as is his right. Copies of both the warrant and the receipt were provided on that day of the search to the former president's counsel, who was on site during the search. The search warrant was authorized by a federal court upon finding a probable cause. Yep, all those things to be true. So yeah, those are all those things that are true. So exciting. I want to change where the camera is located. So I'm going to do that. And this will be fun because it'll just with me. You see, normally you'd have a problem. But here you don't, because you can just move the camera and it'll automatically adjust. Ooh, the camera does get hot. Cool. Cool. All right. Yeah. All right. Let's go back to the document. That's cool. All right. Anyways, change perspective so the camera's a little higher. Also, so the laptop's a little higher, so I don't have to read down as much. So I'll be closer looking into the camera while I'm reading. That's the reason I changed it. All right, carrying on. He then stated in regard to issuance and execution of the warrant. First, I personally approve the decision to seek a search warrant in this matter. Second, the department does not seek such a decision lightly. Where possible, standard practice to seek a less intrusive measure as an alternative to search, and narrowly scope any search that is undertaken. This public statement is deeply troubling, given that President Donald Trump is the clear frontrunner in the 2024 Republican presidential primary and the 2024 general election, should he decide to run. The statement clearly suggests the decision to raid mar-a-lago a mere 90 days before the 2022 midterm elections involves political calculations aimed at diminishing the leading voice. There's political calculations in this which are unavoidable. All facts laid out herein show that there was a complete cooperation between Trump, his team, and appropriate agencies. I think the FBI might have disputes with some of that. Mr. Garland's remarks stray away from long-standing DOJ policy. The decision by the Attorney General to conduct a hastily prepared press conference to announce his intention to release a search warrant was an ill-founded reaction to public outcry that followed the raid on President Trump's house. Yeah, okay. The Fourth Amendment to the United States states the following. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So it has to be under oath, which we did, and has to describe the place to be searched, which we did, and the things to be seized, which we did. So, I mean, it looks like a superficially valid warrant to me. Prior to any indictment, the availability of various grounds of suppression from evidence at trial, the mechanism that protects the rights of individuals from unreasonable search and seizure, is a federal rule of criminal procedure. The rule specifically contemplates protecting the rights of citizens who have been aggrieved by unlawful search and seizure of property. Even the government has done it against transparency in the instant manner, fighting release of the affidavit and claiming a redacted version would be worthless due to the need to hide the actual substance of the sworn statement. There are significant red flags that implicate President Donald Trump's Fourth Amendment rights and cry out for judicial intervention by way of a special master. T-ish in Tennessee gives $3.99. Thank you very much for your wonderful coffee emoji. It is wonderfully appreciated. Thank you. The warrant is facially overbroad. I don't agree, but let's see what President Trump says. Permitting agents to seize boxes of documents merely because they're physically found together with boxes of other items purportedly within the scope of the warrant is clearly overbroad. As instructed by the Supreme Court and the 11th Circuit, the Fourth Amendment requires those searches deemed necessary should be limited as possible. The specific evil the limitation targets is not that of intrusion per se, but of general exploratory rummaging into a person's belongings. I don't think we're quite there because we're seizing documents and boxes of documents. It's not quite, yeah, I don't know. I don't think that's quite on point. Moreover, boxes of personal documents, photographs, and items such as clothing are by definition not contraband, and thus may not be lawfully seized. Photographs could be contraband, depending on what they're photographs of. and personal documents sort of is assuming your own premise. The search warrant's broad scope was in violation of the Fourth Amendment's particularity requirement, and thus a general search. I disagree. Yeah, I disagree. We're looking for classified documents. The documents have classification markings, so that makes them prima facie classified. Now, they might not be because of President Trump doing something that makes them declassified, but they look like they're classified, at least on their surface. I mean, they're marked with the appropriate markings. So on a prima facie standard, right, we're looking for classified documents. So if assuming that we have reason to believe he has classified documents, and he did in fact have them, which is distinct, right? The fact that we can't go fishing, so we have to have probable cause to believe he has them, which maybe the FBI does because they saw them personally when they were in his house previously, right? They saw classified documents. Why they didn't remove them at the time is a good question, but or maybe they have some other reason to believe. I don't know. But let's assume that they had probable cause to believe he has classified documents. And again, they may or may not be classified. We'd have to get into it. But we're looking for classified documents. Okay, so the place to be searched is any place that President Trump has access to at Mar-a-Lago. Okay. And any place that documents might be stored. Okay. We want to seize the documents. Sure. We want to seize the boxes the documents are in. Sure. Because once we find one classified document, then other documents might be also classified. It's reasonable, at least on a prima facie. And we want to seize the other documents that are in boxes surrounding those documents because, again, those would be reasonable places for the classified documents to be. I don't think that falls into the category of just general search. I don't think it's overly broad. I just do not agree with this contention. But they can fight about it and go from there. The investigation regarding President Trump's return of 15 National Archive boxes involved a referral to the Department of Justice based on questions relating to documents falling within the Presidential Records Act. But the Presidential Record Act affords the President virtually complete control over records during the term of office. There's no criminal enforcement mechanisms or penalty on the Presidential Records Act. That's true. Did the Department of Justice National Security Division recognize deficiency and then decide to recharacterize the case as relating to national security materials simply to manufacture a basis to seek a search warrant? Relatedly and importantly, did the National Security Division and FBI mischaracterize the type of documents it sought to be seized as an effort to avoid a lack of enforcement mechanism in the Presidential Records Act? It's not an invalid question. It goes to attack the affidavit that maybe they were searching for things that they were trying to make something criminal that's not criminal. So, not wholly unreasonable as a method of attack. Under controlling Supreme Court precedent, a search warrant violates a person's Fourth Amendment rights as invalid if the person swearing to the oath either makes material misstatements or makes a material omission. Okay. Did the DOJ mischaracterize or omit from its affidavit the true extent of the President's cooperation? That's a reasonable question, right? That's a reasonable question. If they omitted from the affidavit, is this still following me? There we go. If they omitted from the affidavit the President Trump's cooperation with everything, then that might be a material omission because it would go a lot to a lot of these things. So I don't know. And then again, we have to know what's in the affidavit, right? Did they mention all these things? Now, maybe they did mention all these things, and maybe there's still enough probable cause anyway, but if they didn't mention it, that could be material. It's a good question to ask. In addition, did the person swearing the oath fairly disclose any pretextual or dual purpose at work in obtaining the warrant? That they don't have to do. They don't have to disclose any pretext. They just have to disclose any basis, right? We don't get into pretext. That's not a thing. For example, the received property largely fails to identify seized documents with particularity. I'm not sure it has to. The receipt doesn't. But it does refer to the seizure of an item labeled executive grant of clemency regarding Roger Stone. Aside from demonstrating this was an unlawful general search, that is not what that demonstrates, although it might not be a responsive record, but it was taken, so it might need to be returned. But that doesn't mean it was an unlawful search. It suggests the DOJ simply wanted the camel's nose under the tent so they could rummage for either politically helpful documents or support of other efforts to thwart President Trump from running again, such as the January 6th investigation. Interestingly, in the government's response to the motion to unseal the affidavit, the government cites public exposure of the affidavit would jeopardize this investigation and other high-profile investigations. The phrasing suggests the DOJ has other interests at work simply than collecting documents with classification markings. Not wholly invalid points. I mean, I disagree with some of it, to be sure. I disagree that this is a general warrant, but there are valid points here. There are valid reasons to suspect the affidavit. There are valid reasons to suspect that there might be problems. Finally, the elements of national security statuses, such as those referenced by the search warrant, as well as the administrative process of classification and declassification, are complex matters. Did the person swearing the oath fully disclose the strictures of the statutes as well as President's overarching authority to declassify? Yeah, but they don't necessarily have evidence of declassification. So he has the authority to declassify, but having the authority to declassify and having declassified are not the same thing. So maybe they took note, but they'd be like, well, we don't have any record of declassification, which maybe they don't. And they might not have to for it to be validly declassified, but from their perspective, it would be prima facie. So, yeah. These are types of admissions that implicate Franks and could establish a clear violation of President Trump's rights. There's some elements there, to be sure. The FBI and DOJ had demonstrated a willingness to treat President Trump differently than any other citizen. Well, he is a little bit different than most of your typical citizens. 2 years of nosy Russian collusion investigation led to a special counsel finding of a biased FBI agent and officials. Stories of FBI agents engaging in information laundering, where a fired informant continued to feed the FBI false information through DOJ officials to investigate the president, and even an FBI general counsel lawyer falsifying documents to support a FISA warrant, penetration into then-candidate Trump's inner circle. Yeah, the Steele dossier and its related things were not one of the brighter points of time. And to relate to this and be like, the FBI and the Department of Justice has been caught, with their hands in the cookie jar before, on FISA warrants even. So their credibility is a bit suspect when it comes to this. Is not wholly invalid. An assistant director in the FBI was referred to prosecution for lying repeatedly about the Trump probe and the text exchanges between the lead agent, Peter Strzokes, and his paramour, Lisa Page. Paramour is a cute word. You don't see that very often. Reflect their complete disdain and bias against President Trump and his supporters, while they were entrusted with probing the farcical Russian collusion claims. Yeah, that's a bit thing. Yeah, that's interesting. Someone asked what would be enough for me to flip more information. More information, right? I try to assess everything based on its own merits, and as I just said just now, the FBI does have some bit of a reputation. And there has been things against him, and the whole Russian collusion thing is definitely a thing. And there were lies on FISA warrants and all the rest of it, right? So, there are reasons to suspect. There are reasons to question. What would convince me? More information, right? There are reasons to question. I can't reach any conclusions because I don't have enough information. Just because the FBI was truthful in the past doesn't necessarily mean they're truthful now. Just because they lied in the past doesn't mean they're lying now. So, we have to assess everything based on its own merits. The affidavit and having a copy of it would go a long way for me being able to independently assess. So I try to evaluate everything based on its own terms, as always. JKV says that's not usually released. That's true. It's not usually released, which makes it difficult to render an opinion. Right? I mean, it makes it difficult for me to render an independent opinion about whether or not the FBI's search is valid, at least the search affidavit is valid, without a copy. Right? Because I don't know what they know. So, like, everything Trump is saying could be true. Everything he's saying could be true, and the search warrant could still be valid. I don't have enough information. And whether or not I'll ever get enough information, I don't know. But, you know, as people in law sometimes say, you know, you only know what you can prove. And so, you know, that's where we're sitting at the moment. We'll see if we get anything and whether or not it's helpful in our analysis. Without further information from the government, President Trump currently has no ability to assess whether any FBI agents involved in the Russia defamation matter are participating with the National Security Division in the current situation. That would be hilarious if they are. Historically, courts give significant deference to law enforcement representatives who weigh in against non-disclosure of potentially sensitive materials because of investigative need or witness safety. But in light of recent FBI behavior when President Trump is part of the AIM, this court should feel obliged to demand candor and transparency, and not just trust us assertions from the DOJ. I mean, the DOJ's credibility is a bit questionable because of some of the stuff that's happened in the past. I mean, there's a fair point there. The appointment of a special master with a fair-minded approach in providing defense counsel with information needed to support any filing is the appropriate use of the authority. It's not an unreasonable ask. It's not an unreasonable ask to appoint a special master to review this. Someone who's independent of the FBI who can review it. Now, I doubt very much you're going to be able to deny the FBI's ability to review the documents. But to have someone else also review the documents concurrently is not like a wholly unreasonable ask. Of course, then again, some of it's classified, or at least marked classified. So that gets tricky in trying to find the right special master. But, you know, it's not an unreasonable ask. President Trump might be able to get that. President Trump requests this court appoint a special master pursuant to rules of the Federal Rules of Civil Procedure and this court's inherent equitable powers and authority. This step, which the government itself has requested in cases involving seizures of privileged and or potentially privileged materials, is needed to preserve the sanctity of executive communications and privileged materials. Further, Trump requests this court issue a protective order enjoining the United States from any further review of the items seized. That seems unlikely. But having someone else review them concurrently seems possible. The present matter undoubtedly involves such materials. During Clinton's presidency, the issue of privilege, specifically the presumption of privilege, was raised in response to a grand jury subpoena directed to the White House counsel. But it's during his presidency, so it's a little bit in opposite. Right? While he's president, yes, but yeah, when he stops being president, that's the real issue. While the context differs from the present case, it sure does. The court's analysis of the nature of the evidence sought by the grand jury in the case applies with equal strength. The United States District Court for the District of Columbia adhered to the Supreme Court's holding pertaining of evidence sought or seized from the President. When the President of the United States asserts a claim of executive privilege, the District Court has a duty to treat the material as presumptively privileged. Yes, when it's the President, they do. Furthermore, if at any time the documents and materials were created, they reflect presidential decision-making deliberations, they are presumptively privileged. Yeah, but who owns the privilege is the question that comes to my mind. They owned by the president, or they owned by the office of the president, because they're two different things. With the conclusion the materials seized from Trump are all presumptively privileged, I don't know you can go that far, it is unreasonable to allow the prosecutorial team to review them without meaningful safeguard. Short of returning the items to Trump, only a neutral review by a special master can protect the great public interest in preserving confidentiality of communications that take place in the presence of performers of duties because such confidentiality is necessary to the effectuation of the executive making process. I don't think that necessarily holds for former presidents, but I suppose we'll have a legal fight over whether or not it does or not. The DOJ filler team will not protect the president's right. This is normally how the DOJ does this, is to do a filter team. This is normally how they do this. They have a group of people to review documents that are separated from other aspects to deal with this aspect. All right. The government has advised counsel for Trump that it's utilizing lawyers within the Department of Justice National Security Division as a filter team. In certain instances, a filter protocol can serve an important role, where Department of Justice seizes documents that are likely to be privileged. As Justice Manual notes, a filter team, also called a privilege team or a taint team, which is the most fun term, can be used for a limited review of arguably privileged materials to ascertain whether the material is covered by the warrant and protect disclosure of privileged communications. However, rather than relying on the present filter protocol, this court should apply a special master for a variety of reasons. Okay, sell me. The implementation of this filter protocol was procedurally deficient. Why? The 11th Circuit has written that ex-parte communications generally are disfavored because they conflict with the fundamental precept of our system of justice, a fair hearing that requires a reasonable opportunity to know the claims of the opposing party. In Re Search Warrant, the 4th Circuit has specifically noted the problem of setting filter protocols ex parte in reversing a district court's decision denying a restraining order of review of seized materials. Among other issues, the Baltimore law firm court reversed because the magistrate judge had approved a filter protocol without conducting appropriate adversarial proceedings, which will allow the defense to advocate for proper safeguards. In such contested proceedings, the judge could have been fully informed about relevant background of the defendant, as well as the nature of the seized materials. Without the affidavit, the defense does not know what disclosures were made to the magistrate judge in support of the filter plan. Okay. There's some case law precedent apparently from the 4th Circuit on point. We're in the 11th Circuit, but that's persuasive authority. So, noted. And apparently there's at least one 11th Circuit case that's a little bit less off point, but it's something. It's not a wholly unreasonable ask based on the relevant law. Here, too, the magistrate judge approved the filter protocol without input from the defense. Maybe. The result is a protocol that's plainly ineffective. It simply does not ensure the prosecution's team members will not have access to or become aware of privileged material. So we're going to have a fight, it seems, over whether or not they're privileged or not. In principle, whether or not they're privileged or not, which we don't know yet. Because the issue is whose privilege is it? And while he's president, sure, but he's not president anymore. So is it still his privilege? Is a reasonable question. So I guess we're going to have to fight over whose privilege it is. That should be exciting. It might be easier to just appoint the special master and deal with that later. That would be my inclination. I don't know that's what I would do, but it'd be my inclination, right? The issue of privilege is a legally complex question, and I don't know that's ever been solved exactly. So to that end, I don't necessarily want to figure that out now. I'll just assume they're privileged and go from there. So if I'm a judge in this matter, based on this kind of argument, I'm thinking a special master might not be the worst idea. So yeah, I don't think it's an unreasonable ask. I'd be inclined to see if there's some way to do it. I think would be my inclination. I'm not saying I would do it, but I'd be thinking about it. It's not an unreasonable ask. Fundamental fairness requires this court appoint a special master. Courts considering analogous issues have appointed special masters, with one court noting the value of special master in comparison with a filter team. In particular, this court and others have assessed the use of special masters following executions of search warrants at attorneys' offices. Yeah, this is like the first time we've ever done this ever. Context that involves a similar matter of privilege with far less historic importance. For example, in the 11th Circuit, apologize, this is Southern District of New York, I misread that. The U.S. District for the Southern District of New York weighed an attorney's request for a special master after their government had searched her office pursuant to warrant. Accordingly, the court considered the narrow question of whether seized materials should be reviewed by a filter team or by a special master. The court appointed a special master highlighting certain concerns inherent to many filter protocols, including the one presently in place, and the benefits of appointing a special master. The court also cited 3 other courts that have allowed filter teams to review seized materials and later opined that the use of other methods of review would have been better. For example, in a different case, in Vermont, the court noted, with the benefit of hindsight, that it may have been preferable for the screening of potentially privileged records to be left not to the filter team, but to a special master or a magistrate judge. Yeah. Ultimately, the court appoints a special master with authority to determine responsiveness, privilege issues, and whether any valid exceptions to privilege exist on fairness grounds. In appointing a special master, the court noted the importance of establishing a procedure that was not only fair but appeared to be fair, adding that the appearance of fairness helps to protect the public confidence in the administration of justice and willingness of clients to consult with their attorneys. As a general matter, given circumstances here, a taint team is insufficient. They said taint. The appearance of justice must be served, as well as the interest in justice. It is a great leap of faith to expect members of the general public would believe that any such Chinese wall, and that's another name for this historically, it's called a Chinese wall. That's an actual legal term. It's an older legal term, but it's an old code, but it still checks out. Would be impenetrable, this notwithstanding the honor of the United States Attorney. This matter has captured the attention of the American public. Merely adequate safeguards are not acceptable when the matter at hand involves not only the constitutional rights of the president, but also the preservation of executive privilege. And whose privilege is it to preserve is a notable problem here. We're going to have a privilege fight about this. This is going to be entertaining. Trump submits that the appointment of the special master is not only an appropriate action, for it to have any meaning at all, protective orders should issue ordering the United States to cease review of the seized materials. I don't know that you'll get that far, but, you know, getting a special master is not wholly unreasonable. Rule 41F of the Federal Rules requires law enforcement leave a receipt for property with the person with whom items are seized at the location or at the location of the search. According to the rule, inventory, an officer present during execution of a warrant must properly prepare and verify an inventory of any property seized. The rule does not dictate creating inventory, but requires it to be verified, a term that suggests some assessment of the contents of the receipt. The rule requires the officer executing the warrant promptly return it, together with a copy of the inventory, to the magistrate judge designated on the warrant. On request, the judge must give a copy of the inventory to the person for whom or from the premises the property was taken. Attached are 3 pages of receipt of property left by agents for the former president. The receipt lists 45 entries described as box labeled blank or binder of photos. In addition to the documents, they are variously marked as secret, top secret, or confidential. Combined with the sealed search warrant affidavit, the receipt does little to identify the materials that were seized. This level of detail does not meet the standard of the verification requirement. Now, this aspect I cannot intelligently speak to. So I like to highlight issues that are beyond my domain and issues where I have doubt, because I think it's important for an educator to be like, I don't know this. This is beyond my current knowledge base. So yeah, I don't know whether or not this is sufficiently specific. I think it probably is. Because, like, yeah, well, we're taking the entire box because we had the authority to take the entire box based on the search warrant, right? Our search warrant said we could take the document and the box it was in and any related boxes. So we don't need to look in the boxes because there were boxes nearby. And now, assuming that's valid, which I think it probably is, then saying, okay, well, we're seizing the box would be a valid inventory. Like, what's in the box, we don't know. We don't have to look right now. Like, it'll be cataloged later, to be sure. But for the purposes of the search warrant and the seized property, I think this is legally sufficient. But I will say that I don't know for sure. So we can have a fight about that, but it probably is sufficient. But, you know, we can always ask and say it's not sufficient, at least. An inventory of property seized is ministerial. It's something you're required to do. However, it is a matter of fundamental fairness that the agents at least identify from what locations each box of documents was seized. Now, that might be a fair ask. Where these boxes were at the location, or what boxes the agents brought with them. That's fair. That's fair. Because if they're boxes they brought with them, then you'd have to label the things that are in the box. That's fair. And filed. Whether other items were contained in the boxes, they don't necessarily have to look if they were boxes that were there in the first place. Whether confidential labels were based upon labels imprinted on the documents themselves, they don't necessarily know that. They don't have to look. And whether the return label was a result of a review of making that determination. President Trump submits the current receipt of property is legally deficient. Again, a little bit outside my knowledge base. I think it's probably sufficient, but you can always ask for more. Accordingly, the government should be required to provide a more detailed receipt for property which states exactly what was seized and location where it was seized. Asking for the specific room it was seized from is not unreasonable. In addition, Trump requests the court provide him with a copy of this inventory. This, along with inspection of the affidavit, is the only way to ensure the president can properly evaluate and avail himself of the important conclusions. And so we're asking for those specific things. Well, some of those things are fairly reasonable, I think. I think the special master request is reasonable. I'm not sure whether or not he'll get it, but it's not an unreasonable ask. And asking for if the boxes had more specific labels and what rooms they were in, or what other boxes they were near, is not necessarily unreasonable. So there's some reasonable asks here and some relevant case law. So good job, attorney. Good job, attorney for Trump. Some of this is fairly good. I don't know whether or not it'll work, but it's not bad. And then we can see, the receipt for property. They attached a copy of that again. And it just says, binder of photos, box labeled, box labeled, box labeled, box labeled. Miscellaneous documents, miscellaneous, It's a little broad, but it might be legally sufficient. And then there is a certification by the attorney relating to his ability to file this motion, and that brings us to the end of this. Okay. So yeah, I think on the whole, this is a reasonable ask. I think that the location of the boxes seized might need to be a bit more specific, and having a special master appointed is not unreasonable. And then it becomes a question. I suppose the immediate thing the Department of Justice is going to argue, I would think, this immediate thing the Department of Justice is going to argue is it's not his privilege. It's a privilege of the executive, which is us. So there's no privilege issue, would be my argument, and see how that works. But then asking for a special master to look over it is not wholly unreasonable. And the fact also for the DOJ's team being insufficient if it's privileged is not wholly unreasonable. So there's some stuff here that's reasonable. There's some stuff here that's reasonable, to be sure. So I think that it's not an unreasonable ask, and the Department of Justice response should be illuminating. Also, will be interesting to see whether or not this gets consolidated into the search warrant issue, because he filed this separately in an independent action. And so whether or not they will try to consolidate it within the search warrant that's already existing. But we're going to follow it for sure and see what the Department of Justice's response is. If the Department of Justice's response winds up being these documents, even if privileged, are the privilege of the office of the president, to which he no longer has a title, and so therefore there's no problem, if that winds up being the response, it'll be very, very informative. So we'll see how it goes. But I hope you found all this to be interesting, and I hope you found the legal discussion surrounding it to be informative as well. So we'll see what happens next. Okay, well, that's going to bring us to the end. If you have enjoyed this legal education content, please, I ask you to inspect your subscribe button. Is your subscribe button currently red? If your subscribe button is currently red, it is sad and disappointed and feeling a little hurt and even a little angry. The redness symbolizes its disappointment and rage. but it's okay. You can make it up to the subscribe button. All you have to do is simply click the red subscribe button. And if you do, it will become a calm, gray, integrated, at peace, one with itself subscribe button, like it was always meant to be. Help the subscribe button become gray by clicking that red subscribe button today. Don't forget to hit the like button, and did you know for a mere 99 cents, you can become a member of the channel? That's true. Simply by hitting that join button, or by hitting the link that's in the video description, which there might not be in this particular video description, I'll have to double check, or by hitting the link that the bot is telling you about from time to time, you will get the benefits of being a member. You will get the cool scales of justice by your name to show that you are better than the people that don't have the scales of justice by their name. And also, when I'm at home, you get your name on screen as part of the deal, which is kind of nice. So you get all those things. We'll be back with more content. We've got regular videos dropping. We'll have a video dropping, an edited video dropping in about an hour and a half. So looking forward to that. Until later, my friends, I hope all is well. Cheers, my friends, and well, actually, it's about 2 hours and a half. Cheers, my friends, and goodbye.